distinguished participants. So now, as we come to the close of this esteemed MUNSA conference, it is an honor to address you as the Under Secretary General of the Committee on the International Court of Justice. Firstly, I would like to take a moment to express my sincerest gratitude to the Secretariat. The Secretary General Emir, the Deputy Secretary General Eren, the Head of Crisis Habib, the Director General Özgür, the Head of Academy Başar, and the rest of the executive team. You guys are more than MUNers, but you are my fellow intimate friends. Thank you for that. I would also like to take this opportunity to congratulate all the advocates and judges for their remarkable work in upholding the principles of justice and fairness throughout the conference. Your dedication and passion have been truly inspiring. As you bring this conference to a close, I yield the floor to the President for the final remarks. Once again, I extend my deepest appreciation to all of the Chair Board for your contribution to this conference, and wish you all the best in your future endeavors. Thank you. Big applause, please.
I'll start. Honorable Secretariat, esteemed delegates, and fellow participants, I will keep my speech brief. I would firstly like to thank my young family for starting my MUN journey. Later on, I would also like to thank my lovely president, whose name is also Ipek, for being the coolest president ever. I would also like to thank our ESG, Cemil, and all of the MUNSA academic team for helping us throughout the conference. I would like to thank our lovely judges and advocates who worked hard to our committee. Lastly, I would like to thank my best friend, Registrar Birge. She wrote 35 pages of registrar notes, which is incredibly cool. This was an amazing conference. I thank you all. Now the President will deliver our speech.
Well, we all know that the ICJ is a very hard committee to both be an advocate, a judge, or a chair in. I want to start by thanking my Vice President. You were amazing to me throughout the whole conference, and to our Registrar Bilge, you tolerate so much, honestly. Thank you so much for everything you did for us. And I want to take a moment to thank all of my advocates and judges. You guys really pulled through in the past 3 days, and the case was hard, but I'm so proud of every single one of you for your participation. And I hope that you could have fun in our committee, because I know ICJ is very serious. And I hope you were happy and comfortable, and I hope you got the experience you wanted and you learned something. So there is a lot to be said, of course, but I don't want to keep this long. So I'm going to pass the word back to my Vice President to announce our awards, which will be 3 honorable mentions and 2 outstanding awards. So, Ipek, you can start.
So the first honorable mention goes to drum roll, please. Judge Bilge. And the second honorable mention goes to Judge Taşdemir. And the last honorable mention goes to drum roll, please. Judge H. Mahmutoğlu.
I heard some reactions of shock after I didn't announce the best delegates, but that is just how we said to do things, so I hope that's understandable. I will now be announcing the outstanding awards. Our first outstanding award goes to Judge Koçak. Our second outstanding award goes to, drum roll please, Judge Atay. speeches, however, and before we take photos together, there is one more thing to be done, and before that, I wanted to do this separately. I want to say thank you to my team, the Next Gen MUN Academy, and to Mr. Berkay. Thank you so much for being here with me. Finally, we will be giving the awards, and then I want our registrar, Bilge, to come up stage and present the final verdict.
Order of the International Court of Justice. The International Court of Justice, after due deliberation regarding the application by the Republic of Croatia in the proceedings of Croatia versus Serbia concerning the case on the application of the Convention on the Prevention and Punishment of the Crime of Genocide. The court makes the following findings of fact and or law. Whereas the applicant party failed to reach the burden of proof with the pieces of evidence that they have submitted to the court. Whereas the Republic of Croatia hasn't fully considered implementing the equidistant principle on the international law concerning the difference of genocide and war crime. Whereas neither the applicant nor the respondent party's evidences, explanations, and claims about the Operation Storm weren't enough in order for the court to classify the event neither as a genocide nor a war crime. Whereas Republic of Serbia was able to prove that in the Operation Storm, civilians had ended getting harmed, which suggests a two-sided conflict, however wasn't able to clarify that the operation was race-targeted, so could not be classified as a genocide. Neither the applicant nor the respondent party's evidences, explanations, and claims about the incident happened in Vukovar weren't enough in order for the court to decide if the event was race-targeted and classify the event as a genocide or a crime. Whereas the event of Operation Storm that was brought to the court by the Serbia by the pieces of evidences and witness testimonies in terms of classifying the Vukovar massacre as a war crime, since the attacks are two-sided, has no relevancy and therefore it was used against Croatia. Whereas Serbia has not recognized the harms against Croatians occurred during the Yugoslavian war committed by the Serbian groups, nor Vukovar massacre, as a genocide and accepted the fact that Croatians as well as Serbians were harmed during the war, which makes the harm occurred both-sided. Whereas the claim stated by Croatia that in the regions of East Slovenia, Western Slovenia, Banovia, Banjia, Kordon, Lika, Dalmatia, and GNA, and Serb forces had committed killings and caused serious physical or mental harm to members of the Croat nation or ethnic group was not proven to be a genocide. Whereas the claim that stated by Serbia that it is recommended to clear the Serbian government of direct responsibility for genocide and complicity in genocide as Serbia became an independent state on 5th of June 1906 was not proven. Therefore, the International Court of Justice orders, adjusts, and declares that the case shall be dismissed.